start. The facts unfold the plight of a poor landlord languishing in courts for over 40 years. The case gets sadder when we note that appellant had been successful both in the trial court and the first appellate court, and the saddest part is that the High Court in second appeal went against him on a pure question of fact. Issue number 3, framed in civil regular suit number 191 of 1974 for eviction on the ground of unauthorized construction material alteration, decided on 21st 12 1989 in the court of Munsif Bhilwara, Rajasthan, reads as follows: whether the tenant has carried out permanent construction on the plot, thereby causing a permanent change in the identity of the plot against the terms of the rent agreement. Having analyzed and appreciated the evidence of PWs 1 and 2 and also DWs 1 to 4, the trial court came to the following finding on the issue. Thus, all the witnesses of both sides have stated that when the plot was taken on rent, at that time the plot was empty. The disputed plot was taken on rent. Later, walls were constructed, seats were put, and were taken into use as shop and godown. Even today, the plot is being used as shop and godown. Dissatisfied, the tenants took up the matter in appeal before the Court of Additional District Judge First Bhilwara, Rajasthan in Civil Appeal number 20 of 1999, originally presented before the District Judge Bhilwara, Rajasthan on 19/1/1990 and since transferred to the Additional District Judge. In the judgment dated 22/9/2000, the First Appellate Court, after reappreciating the whole evidence, came to the conclusion that, in my opinion, the evidence that had been presented before the subordinate court has not made any mistake in coming to the conclusion that the tenant has made structural changes in the rented accommodation. The appellant tenant has not been able to present any evidence to show that the consent of the landlord had been taken before making structural changes. On such findings, the appeal was dismissed. Thus, there are two findings of fact against the tenants' respondents. The tenants pursued the matter in second appeal number 109 of 2000 before the High Court of Rajasthan, which was allowed by the impugned judgment dated 27/9/2012. The following were the substantial questions of law framed in the second appeal: whether, on the facts and in the circumstances of this case, the learned courts below have erred in granting a decree for eviction on the ground of material alteration while ignoring the relevant considerations and proceeding on irrelevant considerations. Whether, on the facts of this case, the learned courts below have erred in not drawing adverse inference for non-appearance of the plaintiff Damodar Lal in the witness box. The High Court in the second appeal came to the conclusion that the concurrent finding on structural change in the absence of the statement of the plaintiff before the court cannot be treated to be trustworthy. The High Court went further and held that adverse inference should have been drawn for the non-appearance of the plaintiff in the witness box, and in such circumstances the finding on material alteration is totally perverse. We feel it necessary to quote the relevant portion from the impugned judgment. In the considered opinion of this court, such finding in the statement of the plaintiff cannot be treated to be trustworthy or in consonance with law. The trial court was under obligation to draw adverse inference for the non-appearance of the plaintiff in the witness box. On the contrary, it has relied upon the statement of PW1 Rameshwar Lal, who was the previous owner of the property from whom the plaintiff purchased the said property. Stop.